In the past, we talked about the current regulations to the asylum process and how they would have to change sooner or later. Now it seems that this is finally happening due to a Department of Homeland Security and a Department of Justice proposed rulemaking aimed to make the asylum process fairer and more efficient. Join me in today's video to discover what the new proposed changes are and how they can impact asylum seekers at the border. Along with this, I will quickly talk about the budget reconciliation process and how it can affect immigration. I'm Andres Mejer, an immigration attorney and an immigrant myself. I came to the US as a child. I learned to speak English watching Sesame Street on TV. For a long time, my family and I did not have legal status. My parents couldn't get jobs or a driver's license. We fought hard for our green card and got it thanks to an amnesty program implemented by Republican President Reagan. And even after that, I almost lost my green card. I know all the pain and problems that come with the immigration process. And that's why I do this, to inform and educate immigrants like me and help them get their legal status without all the pain that I and my family went through. If you like this subject, please the comments below. If you know of anyone this video could help, please share it with them. Now, if you want to hear more on immigration, please subscribe to our channel. Thanks for joining me. Let's go right ahead with our topic for today. On Wednesday, August 18th, the Department of Homeland Security, DHS, and the Department of Justice, DOJ, took a key step to make the asylum process fair, orderly, and more humane. They announced the publication of new rules that would allow USCIS, that's United States Citizen and Immigration Services, asylum officers to grant asylum, statutory withholding, and withholding under the Convention Against Torture to aliens apprehended entering illegally or without proper documents. Under the current process, these cases are assigned exclusively to immigration judges within the Justice Department's Executive Office for Immigration Review. That's their court. And this process has needed repair for a long time. What this process has led to is the number of such claims has grown exponentially, and the system has been unable to keep pace, having as a result major backlogs and years-long delays in adjudicating new cases. Now, under this proposed rule, the goal is to replace the current system with a more efficient process to adjudicate protection claims fairly and expeditiously. I must mention that this rule would only apply to adults and families who are placed into the expedited removal process on or after the effective date of the final rule. It would not apply to unaccompanied children who are statutorily exempt from being placed into expedited removal. Now, let's see how this new process will work. If an individual establishes a credible fear of removal, he or she will be referred to a USCIS asylum officer who will grant them a hearing on their protection claims. This officer will have the authority to adjudicate in the first instance requests for asylum, as well as eligibility for statutory removal and for withholding or deferral of removal under the Convention Against Torture. What that essentially means is when people think of asylum, there's more than one option, more than one relief that one can get. And in the past, asylum officers only had authority for a small fraction of them. Now they will have authority to grant more things. If the case is denied by the officer, the individual will still have a chance to request a de novo administrative review by an immigration judge. This means that they will have a chance to have their case reviewed from the beginning under a streamlined process. And even after that, there's still the chance to go further with an administrative appeal through the Board of Immigration Appeals. It's also important to notice that even if the asylum officer determines the individual is not eligible for asylum, this rule will still give them authority to grant statutory withholding or withholding under CAT. The difference is principally whether an immigrant can ultimately get a green card or U.S. citizenship through this process. So if someone is granted asylum, they are given refugee status for a year, and a year later, they are able to file for their green card. If they're granted withholding or withholding under CAT, they principally get an order of removal, but because they've shown harm, they are allowed to stay in the United States. And in some cases, get work authorization, but they do not get a green card and they do not get US citizenship through this process and this process alone. What that would mean is maybe in the future they might marry a US citizen, and that US citizen could file for them. That would be an independent process, but it's not due to the asylum process itself. So that is the basic idea under this proposal. But there are a few interesting items that are also worthy of mention. For instance, since the late 90s, the statutory withholding or withholding under CAT could only be granted by immigration judges. So this new rule would change that and grant asylum officers the power to grant those protections. At this moment, asylum officers can approve only an affirmative asylum application filed by immigrants who are already in the United States. What that means is if you come to the United States either illegally and not apprehended at the border, or legally, and whether you overstayed or not, if you file an asylum claim, that's an affirmative asylum claim. Whereas a defensive asylum claim is somebody that's already in removal proceedings. Whether that person present themselves at the border and said, hey, I want to file either at the border or even at an airport, and they say, I want to file for asylum, or they try to enter illegally and are apprehended somewhere, they are in a defensive state. And if they file for asylum, it's a defensive application. A defensive application does not see an asylum officer. A defensive application only sees an immigration judge. This rule changes that and makes the affirmative and defensive applications the same, but also expands the authority of the asylum officer. Like I mentioned a bit earlier, this new rule would also give immigrants 2 extra sources to get their asylum before the right of any appeal. So what happens? They get an interview before an asylum officer. If they're approved, congratulations, they get either asylum, withholding on removal, or withholding under CAT. Now, what happens if they get statutory withholding or withholding under CAT and want the full asylum? Well, we don't know yet, but we're going to find that out. However, let's say that they are denied. They then will go in front of an immigration judge if they so choose. So if they accept the decision, they get deported. If they want it to be reviewed by a judge, they then go through the prior process. Just as before, they're going to have a trial in front of an immigration judge. And if that judge agrees with them and grants them the asylum or withholding of removal or withholding under CAT, well, then if they're happy with that decision, their case is done. If the judge denies their case, then they can appeal before the Board of Immigration Appeals. That's not new. That's existed for many, many years. Again, the new component is that an asylum officer is going to hear their case first, even though it's a defensive application, and the asylum officer now has authority to grant beyond just asylum. And finally, under the current regulations, parole for immigrants in expedited removal is required to meet a medical emergency or is necessary for a legitimate law enforcement objective. What does that actually mean? We're not sure yet. When we do, we'll let you know. This new rule proposes a revision to the criteria applicable to grants of parole out of federal detention prior to a credible fear determination. With this proposal, DHS would be able to grant parole when, quote, detention is unavailable or impracticable, in addition to the existing criteria of medical emergency and law enforcement objectives. Again, nice terminology, but we're not sure how it's going to be applied. Only time will tell. At this point, I want to take a short pause to talk about statutory withholding of removal and withholding of removal under CAT, or CAT stands for the Convention Against Torture. While I have created a lot of content regarding asylum and withholding in CAT, there may be the need to explain what these 2 categories are: statutory withholding of removal and withholding of removal under CAT. So let's start with statutory withholding. What this status means is that the Attorney General may not remove an immigrant to a country if the Attorney General decides the individual's life or freedom would be threatened in that country because of his/her race, religion, nationality, membership in a particular social group, or political opinion. That might sound familiar because it's the same 5 protected reasons for asylum. So, like I just said, it's very similar to asylum, but there is one key difference. It only covers prospective threats to the individual's life or freedom. Me and only me. The fact that that individual, me, was once persecuted in the country to which he or she would be removed to is probably not sufficient to establish eligibility for statutory withholding of removal if the Attorney General does not determine that there is a prospective threat to the individual's life or freedom. In other words, past persecution is not enough. Just because something bad happened to me in the past does not mean it will happen to me in the future. It's also harder to prove. We must show for eligibility for statutory withholding of removal that it is more likely than not that bad things will happen for those protected reasons. More likely than not means more than 50.1% that bad things are going to happen. Now, under asylum, I only need to show that it's 10% probability that bad things will happen to me for a protected reason. But under withholding, under statutory withholding, the element of proof is much higher. Then we have the withholding of removal under CAT, or just relief under CAT. Again, CAT stands for Convention Against Torture. This is the third form of relief an individual fearing persecution can seek. Under this status, an individual carries the burden of demonstrating that it is more likely than not that they will suffer torture if removed to their country of origin by their government. So remember, more likely than not, that means over 50%, over 50.1% that bad things will happen, and it will happen by the government. The advantage CAT offers to individuals that there is no bars of eligibility, meaning it doesn't matter if I'm an axe murderer, doesn't matter what I did in my past life. If I prove the government's going to do bad things to me, then I'm entitled to stay. Since the treaty does not contain any bars to its mandate of non-return, individuals can make claims for relief if they fear torture by the government. Along with this, individuals are not required to establish that they fear torture is because of race, religion, nationality, particular opinion, or membership in a particular social group, like asylum or the statutory withholding of removal. Okay, so let me put some context here, right? Asylum, you really have to prove three fundamental things. One, that I fear persecution. So that means either bad things happen to me or I have a really good reason to believe bad things will happen to me if I go back to my country. Two, bad things are going to happen by the government or a group the government can't control. So what's going to happen to me? By whom? And three, why is it going to happen? So one of those protected reasons. And the why is really difficult to prove. You know, how do we separate ordinary crime from crime on account of race, religion, nationality, political opinion, or membership in a particular social group? So proving why somebody does something is hard. Depends on the circumstances. Now, when you look at CAT, so statutory withholding is very similar, but the elements of proof are higher. It's only focused on me, not so much on others like my brother or my husband or my wife or my child. It's focused on me, and the proofs are higher. But, and this is an important point, many crimes might disqualify me from asylum, but they don't necessarily disqualify me from statutory withholding. Now, Convention Against Torture is based on international treaty, and that the why is no longer relevant. So I have to prove that bad things will happen to me by the government. So now it's no longer or a group the government can't control. It's just the government. And the why bad things will happen doesn't matter. I don't need to prove it. So it's an important distinction to understand. Under the current legislation, only an immigration judge can grant statutory withholding or Convention Against Torture. But as I mentioned before, under this new proposal, asylum officials will now be able to grant them, and that's a big deal. Now, as you can imagine, there are some objections and comments from both sides of the table to this new proposal. While there are claims that this new rule could encourage asylum fraud, slow removals, and encourage more migrants to enter legally, Attorney General Merrick Garland stated that this rule will both reduce the caseload in our immigration courts and protect the rights of those fleeing persecution and violence. And Attorney General Merrick Garland is in charge of the Department of Justice. Secretary Alejandro Mayorkas is in charge of the Department of Homeland Security. And he declared that these proposed changes will significantly improve DHS's and DOJ's ability to more promptly and efficiently consider the asylum claims of individuals encountered at or near the border while ensuring fundamental fairness, adding that individuals who are eligible will receive relief more swiftly, while those who are not eligible will be expeditiously removed. We are building an immigration system that is designed to ensure due process, respect human dignity, and promote equity. Now, both of those sound like nice words. They're well said. Again, the proof is in the pudding. We'll see what happens. There are many positive things we can take from this proposal, and while they haven't shown all the details for this new rule, this seems to be very necessary, and like I mentioned in past videos, something that would happen eventually. We knew that there would be changes, and time will tell whether these changes will be beneficial, but it looks like they will be. The truth of the case, there's a growing number of immigrants arriving at the border under protection claims who are not being treated fairly. And with a huge backlog of cases to deal with, the whole process is in urgent need of reform. These changes are aiming to improve the ways the U.S. immigration system deals with asylum seekers encountered at the border in a more humane and fair process. At the same time, giving some relief to immigration courts, helping them reduce the backlog of asylum applications. Will this proposed rule work? Time will tell. How will these changes be applied, and what obstacles could they face in the future? Time will tell. But for now, it seems like a good step in the right direction. Moving on with a quick note on reconciliation and immigration. When President Biden took office, he promised to send a bill to Congress that would create a path to legal status for undocumented immigrants. I addressed the bill a few weeks ago, and on another video, you can find the link for it below. However, that bill has had very slow progress since its introduction in February. And even the DREAM and Promise Act and the Farm Workforce Modernization Act haven't produced a legislative solution to what President Biden promised. And I previously talked about those bills as well. But there's still some hope with the budget reconciliation process that could be a huge option for President Biden to deliver on what was one of his biggest promises: immigration. What's positive in this case is that unlike normal legislative processes, bills that go through the reconciliation process are not subject to the Senate filibuster. This means this bill could pass just with a bare majority of 50 votes, with Vice President Kamala Harris having the final decision as a tiebreaker. The Democrats could set up a path to citizenship without any Republican support. However, this possibility is not a guarantee, even if they do have all the means to achieve it. For a provision of law to pass through budget reconciliation, it must complete the Byrd Rule, which states that the provisions that are unrelated to the basic purpose of raising and spending money cannot be passed through reconciliation. To achieve this, there is a historic precedent. In 2005, Senate Republicans passed a bill under the reconciliation process that would have increased employment-based immigration by imposing a $500 fee on immigrant visa petitions in those categories. This action offers a blueprint for how Democrats could create a path for citizenship in 2021. Under the budget reconciliation bill, using some form of a revenue-raising fee on applications to obtain legal status. Usually, the decision about whether a bill passes the Byrd Rule is taken by the Senate parliamentarian, who is a lawyer hired by the Senate to rule on these matters. But even if the parliamentarian decided that an immigration provision could not be passed, Vice President Harris could still overturn this decision. This seems to be now the most realistic option remaining for Democrats, given the difficulties that have arisen through normal Senate procedures. And with that, we come to the end of this week's video. Thank you so much for watching. We appreciate each one of you that watches, likes, and shares our videos. We create them hoping to bring more information and give immigrants the tools and knowledge to be more prepared when dealing with the immigration system. If you know someone who could find this information useful, please share it with them. Or if you have any questions, please leave a comment below and we'll try to address it the best way we can. If you need help with your immigration case or want to discuss your situation, don't hesitate to call us. We'll be glad to talk with you. As always, stay healthy and be well.